Yeah, we're gonna speak.
We're going to use the cell phone as a microphone, so let me know if you out there in the virtual world can hear me okay. Presentation's up and going, and I love this background. I feel like we're at the Oscars or something like that. Yeah, it's like, all right, let's break down the movie here. Anyways, thanks, Brenda. Thank you for welcoming back again, and VB Realty Group. This is a service to you folks. I just want to give credit to Brenda and the group here, because a lot of people don't want to set something up like this, and a lot of people don't even want to hear about it because they're like, mañana, mañana, mañana. And the next thing you know, a problem happens. And then that's when people are calling me trying to fix it yesterday, but they don't want to proactively prevent the problem in the first place. And kudos to you guys who are here, and kudos to you guys who are outside in the virtual world here, the Zoom land, listening to us. And so hopefully this will be very beneficial to you folks. I want to concentrate today, because we've already done one of these before. I want to concentrate on this Prop 19 and some of the questions you guys have today, because I know a lot of people want to, oh, okay, we saw the seminar or whatever, but then they go away not asking their questions, and they're not getting answers to them. So I want to concentrate on the questions in Prop 19, but I also want to give you sort of like a refresher of estate planning 101. And yes, I am an estate planning attorney, but I'm also called a probate attorney, because estate planning, hence, maybe you kind of push the clicker thing. Which way am I? Okay, yeah, thank you. If you don't mind, please, I'm holding these things at the same time. Too many things in my hand. Is it going? Anyways, whenever you get to the next slide. Yeah. A lot of people don't understand that estate planning is the proactive procedures or creating the documents necessary to prevent problems. Whereas when we go to court and we're doing probate administration, we're basically acting reactive after somebody passes away, after someone becomes incapacitated. So in a way, we're working both sides of it. So I'm seeing clients to prevent the problems, but then, like I was telling you earlier, where you're like in the middle of an escrow and you come to find out, oh my God, mom or dad became incapacitated through a stroke or something, you can't finish the escrow, or worse, they started the escrow thinking that they had the authority. A lot of times people say, oh, I have power of attorney over my parents and I can do whatever, but they don't realize that the power of attorney is only while parents were alive but incapable. And then they die, and then they still think that they can sell the house, and they find out, and then title tells you, right? Sorry, Brenda, we can't allow your client to sell their property because they're not the vested or the person on title. And then we have an issue. And then all of a sudden they're calling me and emailing me and texting me, how can we get this sold? And I only have so much time, and my buyer is already here and they don't want to wait. I'm sure you heard those. So we also deal, a lot of our cases are actually the reactive and the fixing the problems. So I guess we're here because a lot of people think an estate just predominantly deals with the house, but it's not just the house. It's your bank accounts. It's your personal property, your cars, your investments, your retirements. I hate the word estate actually, because it sounds obnoxious. People think that they have to have a lot of assets, but it's not true. And since you brought up a good point at the beginning, when people buy their home and they may not have that much equity in it because they just put down a down payment and they're making their payments, it's the rights to the home that matters. You ain't able to transfer those rights to that home, which could later have more equity in the future, that matters. And even if people have mortgages on their homes or a reverse mortgage, home equity line of credit, that's okay, because we want to make sure that someone else has the ability to do transactions on it. Okay, we'll go on to the next slide right here. So we can skip this one to here because we already talked about it. So why do the estate planning? That was one of the questions that one of you guys gave me ahead of time. It says right here, what's the advantage of having a living trust? And if you can click it a couple more times, Brenda. One of the advantages is control. You guys can control what to do with your assets before you become incapacitated and before you pass away. I don't know about you, but then you can click it one more time. I don't know about you, but I like knowing where my hard-earned money is going to go, just like Brenda said. And I don't want to leave that up to the court to decide for me. And then another thing too is, I don't know if you guys are aware of this, but it takes about approximately, I don't know if I told you, Brenda, but we're about 1.5 to 3 years going to probate right now. It's not because everybody thinks that I'm trying to go slow and I'm trying to milk the estate. Oh, and Allan is charging so much per hour and stuff. Actually, I don't get paid until the case is finished. And the longer that it takes, the longer that I don't get paid. So the speed of doing estate planning is important because, as you know, one of the valuable things about real estate is the time value of money. If you're not able to rent the place, you're not making money. If you're not able to sell a place, you're losing the best possible sale price, right? So it's also that, the speed of doing it. And then the other thing is that you guys can structure how you can distribute your wealth. And that is really important because if you want the house to be given to a particular child, or if you want the business to go to a particular child that's running the business, because people own business property, not just residential. Everybody thinks about real estate just being residential, but that's not always the case. And you guys can also set it up so that I have a lot of clients that are with no children. Yesterday I had a couple, they have no children. They're basically retired, both government workers, and they're thinking, what do we want to do with our 3 pieces of property? And they're thinking about charitable contributions. And you can also set it up such that you can do that. We'll go on to the next slide. As always, I'm just going to go over the basics today because I want to answer a lot of questions as well. And as you can see, I got a list here. You don't have to do any estate planning. We're not here to sell you anything. We're here to educate you today. No one's saying that you have to do estate planning. We have this thing called the probate code, which handles people who die intestate without a will, without a trust. But the problem is that we're, as a court system, we're underfunded, undermanned, and we're under a lot of stress. Brenda and I were talking prior to the Zoom meeting tonight, how many baby boomers we've been dealing with lately. Every day, 10,000 boomers are becoming 65 years of age, collecting their Medicare, Social Security benefits, and there's about 80 million people strong in the United States. Who do you think is the second largest generation to the boomers? Yeah, the millennials. So the millennials are giving the baby boomers a run for their money. And then what's ironic is that it's been the lowest percentage of millennials that have been wanting to purchase homes because of, look at the environment that we're in. So you got these boomers trying to cash out at high prices, and then the interest rates are high. And then the poor millennials are like, how am I going to afford a 1 point this at 6% interest? But the boomers want to make sure they get enough money to retire, and the millennials want to have a home. So something's got to come in place here to even that out. Anyways, so on to the next thing. Let's see right here. Oh, we're going to talk about Prop 19, but I want to answer another question here. Speaking of boomers, when people pass away and they leave assets, the answer to one of these questions is, if assets are put in a trust and the beneficiary gets a step up in basis when calculating capital gains. Let me simplify this. You put a piece of property in the trust. There's a bunch of beneficiaries. They want to sell the house. What are we going to pay in the way of taxes? There's different types of taxes, obviously. What the person was asking here, capital gains taxes is the difference between the purchase price and the sale price. One of the beautiful things that we have in the IRS code is that when somebody dies, we're receiving the property at their date of death value. So they might have bought the house for ridiculous. You guys are going to laugh at this stuff. I had some clients who buy homes for $15,000 or $30,000. Sometimes less than a car that we buy nowadays. And so it's great for property taxes because we're paying based on our purchase price. And every year under Proposition 13, we don't pay more than 2%. But it's horrible for capital gains. So if he were to sell his home while he was alive, the capital gains from buying the home at $13,000 or $30,000 to today's $1 million is huge. But thanks to the IRS code, we receive the property on the date of death value. So if the house was worth $1 million when the person died and they sell it for $1 million, they've made no gains. So all those years of appreciation they're able to put in their pocket, and the children are like, ching, we're able to keep all that tax free. Now, there's current law right now being proposed. It hasn't been passed yet. Our federal government under the Biden administration, and you guys can Google this over there in Zoomland or here, whatever you guys want, they're proposing to get rid of the step up in basis because remember what we talked about, Brenda, it's the greatest transference of wealth in United States history between the World War II generation and the boomer generation. They're passing about $13 trillion worth of inheritance to generation X, Y, and Z. So what's the federal government says? Well, we just spent a lot of money during COVID, about 9 or 12 trillion, más o menos. Who's counting, right? So we got to somehow pay that back, or we not. And so what they're basically proposing, it hasn't been law. So this step up in basis could go away because they're proposing that instead of these boomers or these people who are leaving their homes paid off a lot of times, they're proposing to charge 40 cents on the dollar and not giving them the step up in basis. So instead of allowing them to keep their $1 million in equity, they're proposing that they're going to charge 40 cents on the dollar instead of being able to keep all that money. Now they're going to have to pay 40% on the $1 million. That's $400,000. Isn't that pretty crazy? Savage, huh? But it's only in the works. Google it. It's called the capital gains proposition. It hasn't passed the House. It hasn't even been proposed to the Senate. So it's something that could be an issue. And I'm only bringing it up because that's one of the questions here. All right. Let me see. I'll wait for these other questions for later because I want to get to that topic. You know what? Before we get to Prop 19, do you mind if we go a little bit further, Brenda? I want to cover the other documents that go with the estate plan. We'll skip some of the Prop 19. Sorry, guys, in Zoom land. We're gonna fast forward a little bit. I promise to go back to Prop 19 and answering some more questions at the same. Yeah, I mean, you guys have it available, and you're recording as well too. Yeah. So, all right. Anyways, just going over some of this other stuff quickly. I want to bang out some of the basics. A lot of people are using online, even using artificial now to create documents, legal documents. It's kind of cool, I think. Yeah, yeah. And so you can compose rap songs on AI. You can you can do haiku poems and stuff like that if you're not so good at obviously wooing your significant other or whatever like that. For Valentine's Day, you can have them write stuff up for you. There's a lot of it's endless limits. So if you do a will, I just want to shortly say, yes, it's a form of estate planning, but it's a little bit better than doing nothing. And the will is really not going to help you because all wills have to go to probate court. So even though you get AI to help you, or you do it on LegalZoom, or you do it yourself on a napkin, a will is basically only your intent, but it's not proof of what it is that you wanted because someone couldn't afford your name. Maybe you guys have horrible handwriting like I do. You can't even read what the hell you wrote. Somebody needs to witness you that you had capacity and you weren't doing the wine will, the wine. I get a lot of people who do that. I hate this person. I love this person. Anyways, long story short, it is a form of estate planning, but we'll talk about that. Each case is individual. Each person has different assets, and the type of estate plan that we use, be it a will, be it a trust, be it giving away assets, or naming beneficiaries on things, or having joint tenants, like one of the questions says here. It all depends on what your wants and your types of assets are. Okay, we can skip this one here, Brenda. Go on to the next one. Like I said, I'm just going to cover the basics real quick and keep on going. I'm not going to waste time here on how long it takes to go through the probate court. You guys can read that yourself. We can skip this part here. It's taking longer because of what Brenda and I were talking about, the boomers and then the World War II generation. And then we only have one probate court per county, in case you guys didn't know. So you guys are here. Cypress is technically Orange County. So the Central Justice Center in Santa Ana is our court, and we only have 4 justices of the peace. I got good news. The Costa Mesa office is going to be open up pretty soon, but we're not going to have 2 offices. We're just going from the 4th floor of Santa Ana to Costa Mesa. So we're not going to have 2 offices. We're still only going to have 1, just so you guys know. That office change is effective May of this year. So instead of going to Santa Ana for your court hearings or your Zoom meetings, now everything's in Costa Mesa, in case you guys didn't know. Oh, keep on going. I just wanted to go over the other stuff right here. Dulce gave you guys a lot of stuff. My assistant. Yeah, keep on going. Keep it going. I think she did overkill this time. All right. So going to the probate issue, the reason why the courts are overburdened, 1, we only have 1 court. Number 2, we have a huge demand with the World War II and baby boomers. And then number 3, we're underfunded. So I don't know if you guys know this, but in 2013, we got defunded. So as of the last 10 years, that's why we only have 1 probate court per county. So there you go. We'll skip that part. You guys can read all that. Okay, keep on going. All right. I wanted to go, besides a good trust that we are talking about, the other documents that people need to set up is a good healthcare directive. And the healthcare directive is mandatory anytime you guys go to the doctor's office. I'm probably sure when you go to the doctor's office, what's the first thing they ask you is, how are you going to pay, Brenda? Yeah. And then where's your healthcare directive? Because they don't want to do anything without getting paid, right? No offense to the doctors out there or nurses. We love you. Thank you for helping us during COVID. But the healthcare directive is really a simple thing to do. A lot of people think that, oh, it's only for old people. It's for anybody. Anybody who's 18 and older that can't make their medical decisions should really have this. When my daughters went to university, one of the first things that we needed to do, because we couldn't go in with a doctor with them or get their patient chart or make appointments for them, was to get a healthcare directive for them. And it covers anything from minor decisions to open heart surgery to end of life decisions, if you want to be kept on artificial life support or not. And it even works post-death for anatomical gifts, autopsy and autopsy, funeral and burial. It's all inclusive. And this is the document that the state of California has used for the last 20-some years. And this is one of two documents. One more document, Brenda. I think we're going to keep on going right there. The financial power of attorney. This is a hot topic for you. Since we talked about dealing with boomers, have you had clients? I'm going to involve you in this. Yeah, now I get to interview you back. Pretend this is a microphone. Have you had any of your boomers or World War II generation clients have their children act as power of attorney in the sale of their home because they want to make sure that mom can't walk up and down the stairs, or too much home for mom and she can't live at home because she broke her hip, or mom is suffering from dementia? I keep on saying mom, it could be dad. Yeah. And then now the kids are worried about them, and they're using power of attorney so that they can put mom or dad in a safe environment that they can't hurt themselves or allow other people to take advantage of them. Have you run into a situation where people are using power of attorney?
Yeah.
So this is critical, guys. So the power of attorney is an important document, and a lot of people are fearful of it because they think, oh my God, I'm going to give away my rights to somebody. Powers of attorney are a very powerful instrument, but it's a very effective instrument. And the reason I bring this up with Brenda is because of the aging of our population. You're going to see a lot more people using this and needing to use it, because I wish I had a crystal ball where I knew personally that when I was going to become incapacitated, I knew exactly when, but I don't know. It could be years, it could be months, it could be weeks. And nobody knows this. And everybody thinks and assumes that automatically it's mom or dad or an elderly person. That's incorrect. I recently, September, end of August, September, I was mountain biking, and it was just my regular mountain bike thing. And I fractured my 7 ribs, separated my shoulder, and had a collapsed lung since I last saw you. Yeah. And then for a while there, I couldn't even lift my arm. I couldn't bathe myself. I couldn't do anything. I was on medication. And then they even put like this big needle on my chest, basically to let out the pressure because I had a collapsed lung. And so I had that in there for about a week. It was crazy. And so I was incapacitated temporarily. It wasn't that I was cuckoo for Cocoa Puffs or something like that. It's just that I couldn't sign my name and I couldn't do a lot of activities, and I was on medication. So I was temporarily incapacitated. With the power of attorney, somebody could basically handle my affairs for me. If it was tax season, someone can sign my tax returns, deal with my banking, deal with my retirements, or better yet, with my insurance, making sure that, hey, since I can't be on the phone for 5 hours with the insurance, not just kidding, they can handle it. Put them on the, here's my power attorney. You be on the phone for 5 hours. This is critical. A lot of people always concentrate on the one for healthcare, but they forget about the financial. And in your situation, trailing back to you, you have to be ever so careful nowadays, because you're trying to make sure that you do what's right for the ultimate client is the mom or the dad. And you want to make sure that they are not being manipulated by the child. And so oftentimes title and escrow want to see these powers of attorney updated up to 6 months, up to a year. I work with different title companies, and they're very strict on this, in that they don't want to be the party or perpetuator of a fraud or an elder abuse situation. So these are great to do, and they need to be created, but they also need to be reviewed, and they also need to be updated. There's other common things that people don't know about. And how many of you guys in Zoom land or here know of Tom Brady? All right. Hurts.
I heard of him.
Or how many of you guys heard of Tom Cruise?
Heard of him.
So Tom Cruise, Tom Brady, I'm going to give them credit. They're smart guys. They do well what they do, acting or formerly playing football. But do you think that they actually negotiate their contracts year to year? Or do you think that they hire an agent? And that agent, like in the movie Jerry Maguire, right? Show me the money. That agent obviously wants the best deal for Tom Brady, if he's going to go back and play for the Buccaneers or not, or whatever. But he's not negotiating the deal for himself. He's using power of attorney. So power of attorney is delegating someone else the responsibility to do what's in your best interest. It doesn't have to be incapacity. It could be because they're acting as your agent. Same thing with Tom Cruise. Do you think he's negotiating how much he got paid for Top Gun 2, whatever, the crazy amount of money? His agent negotiated that. Obviously, what's incentivizing the agent? the commission, because they're making what, 5 or 10% off $100 million movie. That's not bad cheddar. So I'll be happy to be his power of attorney. Sign me up, Tom Cruise, if you're out there, or Tom Brady. Sports agents, wow, I miss my profession in that. No, estate planning is cool. I still like doing what I do, but that's more sexy. That's more lucrative. So now you see how powers of attorney can be used in everyday life. They're not what most people think. So we talked about the healthcare directive. We talked about the power of attorney. Then we talked about the will not being helpful. Now we're going to talk about trust, and then we'll go back into Prop 19.
For power of attorney, it does seize upon death.
Correct. And that was another thing we talked about. Thank you. See, keeping me on my toes. The situation we talked about earlier is that a lot of times, somebody might come into Brenda and hire her, and then she has power of attorney, and then the person who they're represented gets worse. They had a baby stroke, or then they get a major stroke and they pass away. And then now you have a situation where if the person didn't create a trust, which we're going to talk about next, now we have to go through probate. And now everybody's scrambling to basically get a court order to be able to consummate the deal. But because the power of attorney, once the person dies, that's it. We can't use it in this scenario. Obviously, if Tom Brady dies or Tom Cruise, they must have their estate plan set up, and obviously their family would get the deal. So, but if they don't play, they don't get money. And if they don't make the movie, they don't get money, guys. That's the way it works. Anyways, let's go to the trust. Sure. Correct. Yeah. And so the question was, what about powers of attorney between husband and wife, right? Or husband and husband, or wife and wife, or your significant other. I had a client today whose daughter is married to her partner, another woman. So I have to be PC. And so anyways, if you have a partner, yes, California is a community property state, but just because we're partners, hypothetically, just because we're partners, we're still individual people, and we still technically own half of the house. And if I wanted to do something different from Brenda, I would still need her permission, because it takes two of us to make that sale happen. Or for example, if Brenda had her own CalPERS or CalSTRS pension, that is her individual retirement account. Although I might be named as a beneficiary. You better, no, just kidding. I don't have the power of attorney to make changes on her retirement. Let's say she's disabled and she needs to take out money. I would need a power of attorney to be able to do that, because that's her individual retirement account, her Social Security. You see what I'm saying? So a lot of times people assume that just because you're partners or you're married in California, that it's an automatic, but it's not necessarily an automatic.
Good point.
Very good point. Skip all this and we'll go to the trust. Like I said, we'll hit this one, Brenda, because that's one of the questions here. I'm banging these out as we go along. And then joint tenancy. Okay. So one of the questions right here was, and I'll read it to Zoom land and to people here. I'm just reading verbatim the question. It says, two unmarried people transferring a home currently titled in joint tenants through a trust to a nephew. Do we need two separate trusts to do this? Should title be changed to joint tenants in common? So that's what the question is. You can create a trust between any two people if you want. At the end of the day, what a trust is, it's a contractual agreement between one person or two people. You don't have to be married to create the trust. You can be still partners, and you can put that asset, such as the home, into the trust. And if we held title as joint tenants, by the way, you don't have to be married to be joint tenants. Everybody assumes that for some reason. I don't know why. Brenda and I could be joint tenants on a piece of property that we invested together, and she doesn't necessarily have to be my partner or my spouse.
Hey, down.
And so that being the case, we can do what's called a trust transfer deed into the trust. And then if we both agree that her nephew and my best friend, who happens to be her nephew, want to be the beneficiary of that jointly owned property when we both die, we can create a trust to that effect. That's not a problem. Now, it's not always the case that we have somebody in common, because she might say, hey, I want my half of the property to go to X, Y, and Z, and I want my half to go to A, B, C. So you can also do that in the trust. And that was one of the questions that people set up. You're using the trust as a vehicle to basically have your wishes done after you guys both pass away. Because one of the problems with joint tenancy, as you can see up there, is you're only postponing probate between Brenda and I. But what if we both die? now we have a problem. That's why we want to use the trust as a vehicle, as a continuation after us. Also, one of the other problems with joint tenancy is incapacity. What if Brenda becomes incapacitated and I want to sell the property because I want to cash out, or we want to refinance? I need power of attorney for her. And if I don't have power of attorney for her to do the refi or to sell the property, I'm up the creek because I need 2 signatures. Also, if, for example, I became partners with Brenda, I heard this this week or last week that somebody added them only as a convenience to joint tenancy, but they weren't necessarily the originator, the down payment, or the original person who purchased. The problem is once you add somebody to title, they may not want to be removed. And if they didn't contribute as much as you did, you just basically titled them onto the real estate, and now they became a half owner with you without having to put any earnest money down for a down payment or making payments to the home or sweat equity. So you have to be careful who you make as a joint tenant, because once they're on there, they're on title and they may not want to come off.
We've seen that happen where people add people on title for, you know, Medi-Cal reasons. And we had one where the parents gave it to the children because they thought they weren't going to qualify for Medi-Cal. And now the children are like, well, we own it now. You're not getting it back. And they will not transfer it back. And the truth is, I mean, they didn't have to do that because you're allowed to own property, your own primary residence. But we've seen that happen.
Yeah, my favorite is that, oh, I'm helping pay mom and dad's mortgage, and we have to be on title in order to do that. Bullshit.
Yeah.
I talked to my accountant that I've known since 3rd grade. I'm like, hey, Matt, is that true? It's because they're helping the parents, pay the mortgage interest and property tax, and they want to deduct it. No, as long as they can trace the funds from where the source is, and they can obviously show that they pay that interest, they can make that deduction on their income taxes. They don't need to be put on title. And that's one of the oldest tricks in the book. So anyways, as you can see, there's other problems with joint tenancy. I don't want to belabor this point. Lawsuits, if your partner has a lawsuit against it because they drive the Ferrari into a person. Remember last year, you guys remember that lawsuit? The dad let the son borrow his Lamborghini Urus, the SUV, and then the son hit this lady crossing a crosswalk, and they got sued for $18 million. So your partners could subject you to potential lawsuits. They can subject you to tax problems and debts. If you're thinking that, I'm thinking Brenda's paying the property taxes, but she's not. Brenda, what happened? I thought you did. Sorry. Whoops. I forgot to do that. So anyways, that was the answer to the joint tenancy. And I guess if you want to flip over to the trust, I was going to go over that. And then I want to start getting to Prop 19 because we only have so many. This is a no-brainer. Brenda just touched on it. You don't want to give away your assets because I don't know about you, but unless you're Elon Musk, I think you still need your house, your bank accounts, and your cars. But I have had some clients because they thought, oh, the classic one is, you're going to take care of me. My mijo or my mija is going to take care of me when I get older. So I'm going to put title in their names. And I had a client who had a duplex in Hawaiian Gardens and did that. And what happened was that the daughter and her husband and her kids were living in the front duplex, and then she and her husband and my client were living in the back, and she titled it to her because she had I don't have enough fingers here. She had 4 children, and this is her 4th child, and so she trusted her. She was the youngest one. So what happened was that the husband and the daughter, the son-in-law and the daughter, broke up. She wasn't no longer attentive to the husband nor her parents, and she was swiping left and swiping right. And then that promise of taking care of the parents went away. And then they already gifted the property to her. And we wrote her a letter saying, hey, would you be willing to sign it back to the parents? And the answer was a negatory. So don't give away your assets. Anyways, you can skip this. I hate that one. Keep on going. So we're trying to see if we can get to the trust part. Oh, you know what? I think the trust was back. Yeah, sorry. Yeah, it was back. Yeah, keep on going back. Sorry, Brenda. Like I said, I want to make this productive and answer the questions, and I wanted to get to the Prop 19.
We have a question from Zoom land, so maybe you want to answer that one.
Okay.
Your spouse, 10 years.
Oh yeah, I'll read it off the screen. My spouse is 10 years younger than me. Way to go. But I don't trust him. Oh, wait, okay. This is juicy. But I don't trust him to leave our home or money to my son from a previous marriage. I just had this question this afternoon before I came here, where this blended family basically, and then the same scenario, the wife and the husband shared one child in common, but the wife had another daughter from another marriage. Can I do something to make sure my son gets something upon my husband's death? Well, I'll have you guys know, you see how many ladies are here? And there's only 3 guys. Us guys die faster. It's a known fact. If you go on Google and you go to the Social Security Administration, the life expectancy of guys is just a fact. We have a shorter life expectancy. And why do you think Social Security is so important to Google? Because how much do they deal with? They deal with billions, if not trillions of dollars. So they have to be super accurate. They have that money reserves, and then that's why they keep life expectancies. And so they know exactly, or more or less, according to the bean counters, when somebody reaches a certain age, they're going to live so long. And so, number one, yes, your question is valid. I'm not saying that you're guaranteed to outlive your husband, or don't give him the, what do you call it, the iced tea, like murder ID and stuff like that. Don't do anything like that. But assuming that you don't outlive your husband, which the odds are small, there's many ways of taking care of your son. You can also set up like a life insurance policy where that son is taken care of outside of your state. You can even set up an account right now where people can set up like a stock account or a savings account and put a little bit of money aside so that they are named as beneficiaries on that account. You can also set it up in the trust such that the trust becomes irrevocable when one spouse passes away. I think that that's kind of handcuffing yourself, but that is something you can do. There's many ways of taking care of your son. It just depends on what assets are in the trust and what assets are outside of the trust. A lot of times where people have a blended family, they want to give their assets that they've earned together to the children of the same marriage. And then there's children from previous marriages, and they might exclude them, or they might set it up such that they get assets outside of the house, that's the family home, but they can get other monies such as bank accounts, investment accounts, insurances, and take care of the stepchildren that way. All right, so that's an answer for you there. Oh, we got a question from the gallery. Yeah, you can. It just depends. Oh, I don't think the Zoomers heard his question. As a blended family, can you have separate trusts? And the answer is yes. I had a situation, so many situations I have, where there was a fireman and a school teacher, and then they had already been once married and had 2 kids each, and they each had their homes. And so they had their separate trusts, and then they had their homes in there, and they had their separate, pensions, their CalPERS and CalSTRS. And then they made a joint marital trust. And then in the marital trust was any assets that they accumulated together during the marriage, but they kept their other assets separate. In addition to the joint trust that they had in their separate trust, they also had prenups so that they can keep those assets separate and the debts that they accumulate separate. So think of a prenup like no offense, Brenda, but like a border where Brenda can't come over and obviously claim my assets. And at the same time, she can't, obviously, I won't be responsible for her debts. It's not just assets, also debts. So you can do that. It's a lot more sophisticated, but obviously the answer is yes. Long story short. Okay. And then did you want me to answer another question or keep going on? Did you find the trust stuff?
Is it the trust? Because I went all the way back there into the trust.
Oh, I'm sorry. It should have been on there. It should be like, trust and benefits for trust. Oh, if you want to leave that chart up right there, that's fine, Brenda, right there, the one right behind. I can just go off that. Don't worry about it. They can look it up themselves. They're very smart people. Anyways, I want to cap this off so I can get into Prop 19 because there's going to be a lot more questions. So the trust, as you can see, is one of 6 options on the big screen. And everybody thinks that that's the only way to go. That's not true. It just depends on your situation. If you are a young person and all you have is a bank account, a car, and maybe a savings, maybe you don't need a living trust. Maybe you just need the healthcare directive, the power of attorney, and you can put beneficiaries on your bank account and your investment account. How many of you guys here have apps for Robinhood or for Acorns, right? They allow you to put beneficiaries on there, right? And you should do that right away. And you can name your sibling, your parents, whoever you want, your significant other. It's an easy thing to do. Beneficiary designations is a form of estate planning. You guys, all of you here have done a form of estate planning, whether you know it or not. When you open an account and put a beneficiary on there, that's a form of estate planning. When you added your partner to joint to the account or joint to the house, like Brenda and I, we did a form of estate planning. when we gave away for the birthday, I saw it was someone's birthday not too long ago. That's called an irrevocable gift. That's a form of estate planning, making a gift. Obviously, doing nothing is a form of estate planning, but it's not recommendable. But we have the probate code, at least. We're civilized people, and we have that code to take care of when people don't do anything. And then, of course, if you did the will, like we talked about earlier, you did a form of estate plan. The revocable trust works. It's just, is it appropriate for you? And sometimes people don't even have real estate. I had a family who had 5 children. They're very busy, all 18 and under. And all they had was the liquid assets, the bank accounts, the investments, and the life insurance policy. The gentleman had a life insurance policy for $2 million. Of course, he wanted to name his significant other as his first beneficiary, but the kids were originally put down as contingents, but they're all 18 and under. They don't have the mental capacity to basically open a checking account. They don't have driver's license. They don't have the ability to sign a contract. They're not 18 and older. And so he decided that the proceeds, after, if he and his wife passed away, would go to his trust, and then they would basically be used for their healthcare, education, basic necessities until they became a certain age. And it had nothing to do with real estate. I don't know why everybody thinks that you have to have real estate just to set up a trust. Remember, I told you at the beginning, one of the questions was, what is the advantage of a living trust? It's control. It's basically, you want to control how things are distributed upon your death or upon your incapacity, hence the power of attorney, hence the healthcare director, right? So the living trust is also good for a lot of these folks. Brenda and I were talking about this. Oh, everybody's moving out of California. Don't move. We want you here. And so we were talking about, what is it? Texas, Idaho, God forbid, Utah. It's cold over there. And then what else were we saying? Montana. Yeah. Anyways, Tennessee, and then obviously Texas. We already said that. So the living trust, if you have a living trust set up here and you happen to be an investor outside and you keep your property here, you can put those properties, even though they're in a different state, in a different county, you can record them in the name of your trust. And if you pass away here, your family doesn't have to go through probate court in Utah or Texas or Idaho. A lot of my clients have been investing in Mojave County, Arizona, Blythe, Colorado River, the river, they like taking their boats and having a good time. Clark County, Nevada. You might have heard of this place called Las Vegas. That's Clark County, Nevada. Yeah. Concerts and stuff. A lot of people like buying condos and stuff like that. And they've been having investment homes and properties there forever that I've transferred into their trusts. And then, of course, right now, people are moving actually, or they're buying a second home. So the living trust is also helpful for that.
I have a couple questions.
Oh, you stop me because I keep on going.
Scroll down so we can look at this. I think
You pick one, Brenda.
go back up. Yeah, sorry.
And then you want to read it since you're there?
Okay. It says, you showed a table that I think said $1 million estate could have 30,000 costs and probate costs. What would it cost using a trust, including the cost to create the trust and then to settle the estate?
Yeah. It's a very good question and honest question. Now, for example, to set up a living trust, you can go, if you want to use my website as a reference. For a married couple, you're looking about $1,400. For a single person, you're looking about $1,000. We have packages. Not all attorneys are charge as little as I do. I don't know why I haven't been raising my prices, but anyways, that gives you a guesstimate of how much that costs. But this is a typical situation where you have the trust, the will, the healthcare director, power of attorney, and perhaps they have one piece of property. I had clients that coming in with multiple properties and businesses or intellectual property, or they have LLCs or S corps. So obviously that's going to accentuate the cost because there's more work involved in transferring those into the trust. Now, as far as winding up the trust, the administrative costs, that depends on what assets are in the trust. If we're just talking about real estate, it's a question of, we can sell the real estate out of the trust. And then now you have to, should we incorporate Brenda's fee for yeah, because she worked her ass off, and that's a cost of selling the house that you would already have to pay to sell the property out of the trust. But it all depends on the assets that are in the trust. It could be as simple as a life insurance policy where we basically go to life insurance, collect the funds, put it in custodial accounts for those 5 kids. Or it could be where we're involving real estate and we have to sell the real estate, put the funds into a trust estate account, and then make distribution after all the debts are paid and all the income taxes. What was last Tuesday, guys? tax day. And just because someone dies means that they get free, no taxes? No. So Brenda's all no. Didn't we get an automatic extension?
Well,
I thought we did.
yeah.
We could file until October, right? That's what my tax guy did. And I did my taxes in March. He's like, oh, you could have filed in October. I was like, great. Yeah, you might as well pay me now, pay me later, right? Anyways, so yes, I can't give you an exact cost of what it's going to be to wind up a trust because it all varies. If I gave you an exact number, then you're going to say, Allan, you told me this much, and it's not that much, it's this much. So it all varies on the types of assets that are in the trust, the complexity of the trust. And obviously people have assets outside of the trust, which don't even require trust administration. Why do you need me to go to a bank just to show a death certificate, your ID, and collect the bank money that's you're named as a beneficiary? I tell my clients, you can do that yourself. So good question. All right.
There's another one. It's,
Oh, you need to.
yeah, one more question. It's from Kip. Whoever is named as the beneficiary on an account will override what is in the will. Correct? Question mark.
Yeah. No, that's a very simple question, and the answer is yes right away without beating around the bush. Why is it that a beneficiary designation beats a will? Anybody here play poker? I'm just kidding. You know, in poker, there's obviously higher cards and lower cards, you know. In a beneficiary designation, you've already made a contractual agreement with who? With Bank of America or Chase or Wells Fargo. And that's called an agreement that if you pass away, it's called paid on death or POD or transfer on death. And by making that agreement with the bank, they know what your wishes are. So there's nothing else to do but to complete the contract. It's a contractual agreement. The will is me going in front of Judge Brenda and saying, hey, we'd like to submit this will to start the process of administration. So a will is starting the process of administration. It's not saying that you got automatic rights. You can have a will that's contested by people that say that that wasn't the will that my dad last drew up because I remember him doing it this time. So a will is just a starting point. You can't just take the will into Bank of America and say, hey, I'm supposed to get everything. Here you go. They're going like, yeah, go in front of the judge first and then come back with a court order because that doesn't mean squat to me. So that's what I want to put in perspective. Does that make sense, guys? Okay. All right.
Should we do Prop 19?
Yeah, we should do because I'm going to kill you guys on time and I don't want to. I know everybody wants to get to their dinner and stuff. Although these guys are having it nice here. The lazy chairs and dinners. No, it's okay. It's okay. Enjoy yourself. I'm only starving up here. No, I got to give you guys a little bit of heart. The reason I want to bring up this hot topic is because this was passed during COVID. We voted on it, and it passed by a narrow margin of 51%. And in the slideshow, we'll get into it in just a second. I just want to give you the background. The background of Prop 19 was that, remember when we had all the floods and all the fires, my friends in Santa Rosa lost their home. They moved from Long Beach to Santa Rosa and their home was burnt to the ground with those fires that happened out there. And so the idea is that, hey, disaster relief, we want people to be able to replace their homes and rebuild comfortably, not be reassessed at the yin yang because they lost their homes. And how is that fair that they did the home so many years ago and now they're having to replace it and the cost of replacing the home is a lot more. That was one premise. The other premise was for people that are 55 years and older or disabled so that they can take their tax basis from when they bought their home for $30,000, they can take it to another county and keep on paying that same tax basis. Certain counties play nice with each other. You know how many counties we have in California, Brenda? 58. So if you move from Los Angeles to Orange County, they played nice. So if you bought your home in Los Angeles County in Downey and you bought it for $30,000 and now you want to move to the OC and then this new OC home, the fair market value is worth $800,000, you can still pay the property taxes based on your original purchase in your house in Downey. That was called Proposition 1690. But not all counties play nice. Guess which counties didn't play nice? Riverside County and San Bernardino didn't play nice. So if you went from LA to Riverside and to San Bernardino, they're like, forget you, buddy. You're going to pay whatever it is to buy the McMansion out here in Norco and Eastvale, which is all of a sudden we were talking is like starting to go up horse country. And so now with Proposition 19, you can take your basis from your home to anywhere in California, and you're not limited to just one time shot and that's it. You get up to 3 times. And so this is what was being pushed during COVID. And then under it all was the parent-child and grandparent-child transfer. And they kind of like said, you know what? This is not fair. One of the famous actors, the Bridges, I don't know if you know Bo Bridges or Jeff Bridges. They were inheriting a home from their father. I forget, in Beverly Hills or something like that. The exact location. Don't crucify me. But they're inheriting a home, and then they weren't going to live in it, and they were going to still keep on paying the property taxes that when their dad bought it, which was really low, and they were going to rent it or whatever. And then that caused a lot of social outcry, saying this is not fair. These guys are super rich. They're actors, and then they're getting this home. Why do they only paying like $2,000 a year in property taxes, and the rest of us get stuck with all these high property taxes? So there was a social outcry, and then they basically said, "Hey, we want to narrow the scope of when somebody dies and they leave a house to their children, what they can do." So here's Prop 19. So before it was called Proposition 58 and 193. 58 for the parent-child, remember that, Brenda, and 193 from the grandparent-grandchild. And so before, if you were a parent and you were giving your home to your child, it just needed to be your principal residence. Didn't have to be theirs. And they can obviously move in it or not. And then there was no value. So if you bought that home in Balboa Island, you guys know where Balboa Island is? It's pretty cool over there, right? I know some people buy Balboa, and now those homes are going for 3 or 5, right? It's crazy. And so there was no limit. You can still pay your parents' taxes. But now they said, party's over, guys. Now, if you want to keep your parents home and pay the same taxes they do, it has to be your principal residence as well. And you have to, within 1 year, you'll look at the information in a second, you have to do a home declaration saying that you intend to move there or be there, a permanent resident there within a year after your parents' death. So they've narrowed that straw. And then on top of that, they put a cap on it. So that Balboa home that now is worth fair market value, crazy. Or you give me some names like Villa Park or whatever. I'm sure you know nice places, right? Now the cap is at $1 million. So the way we calculate the cap is you take the current what they call assessed value or base value, and then you add $1 million to that, and that becomes your cap. Anything below that, you don't get reassessed. Anything above that gets reassessed. So there's some examples in here. I know this is like math. Everybody's going to go to sleep right now. They're like, oh my God, Allan, this is so freaking boring. But it's important if you're getting your parents home and you don't want to pay higher property taxes. So you guys might want to go home and tell your parents to do their trust and just give you the house, not to my brother. No, just kidding. Don't do that. So you can go to the next slide here. I'm going to stand up here a little bit. All right. Okay. So this is what I told you. It was narrowly passed by 51%. Isn't that crazy?
Yeah, so close.
And Skip, oh, by the way, we had this seminar. This information was I'm a member of the Orange County Bar Association, and we're always doing what's called mandatory continuing education, MCLE. I'm sure you have to do continuing education as well, too. And so we ourselves are all constantly learning as well, too. So this is just recent, February 20th, almost March. You can go to the next slide and keep on going to the next slide. Okay. All right. So it says a little thing right there, but I'm sure they can see it in Zoom land without that. Anyways, one of the common misconceptions, oh, thank you. We're getting, hey, there we go. Thank you very much. One of the common misconceptions, and you'll see on the next slide here in just a second, if you want to go to the next slide, Brenda, is they think that Proposition 19 basically replaced Proposition 13. I don't know if I see it there, but you'll see it in a second. That is not true, number one. Proposition 13 is like the grandfather. We're all under Prop 13. She is under Prop 13. You're under Prop 13. He's under Prop 13. He's under Prop 13. She's under Prop 13. We're all under Prop 13. It just depends on when we bought our homes. Us poor schmoes that bought in 2005 and 6, and we paid at the height of the market. Remember, Brenda? We were paying out the nose because we bought at the height of the market, whereas somebody else bought at the low market. And so obviously, if you and I bought back then, give me a number. What's 2005, 2000?
Oh,
600.
gosh, here, probably 600,000.
So 1% of that is about $5,000 or $6,000 in property taxes. What's 1.5? You just do like half of 5,000, 2,500, 7,500 to $9,000 in property taxes. Does that suck or what? Right? And whereas the other person's paying a lot next to you, paying a lot less because they bought in 1950 for $30,000. But their basis was low. So they only started with that small basis, and each year it only increased 2%. We still have that out there in Zoom land and here. That hasn't gone away. What's only being changed is the Proposition 58 and 193, which is under the Prop 13 umbrella. That's where a lot of people think, oh my God, Prop 13 went away. It hasn't gone away. Oh yeah, here we go. You're on the right thing. Yeah, you hit it right. Thank you. So these are some of the common misconceptions that I wanted to demystify out there, because this is jewels or pearls of wisdom here. Number one, Proposition 13 is still alive and well. Number two, a lot of people think that, oh, if I have a home that's worth over $1 million, I automatically going to get reassessed. It's not true. It's your base value plus $1 million. So if you have a base value of 300, 400,000, you add that to your 1 million. So now if you have anything above 1.3 or 1.4, then there could be a possible reassessment, but below that, no reassessment.
That's whether it's your primary residence or not.
It has to be your primary residence on the Prop
You get
19.
$1 million.
Correct.
Otherwise, you don't get anything.
Here's the bad news, because we used to give 2 properties to our kids with no tax increases. We used to be able to give our primary residence under the old law and then a second home, but now the second home has been eliminated. So you could have given Mijo a home and then Mija another home, and then they could have been paying the same property taxes and everybody would have been hunky-dory, but they slashed the second one away. Good point. Another thing too is that, here it is. You have to make it your residence, and then they're like wondering for how long. There is no set time period of how long. You can be living there forever, but obviously if you don't make it your primary residence, they say, hey, do you lose it? No, it's not necessarily lost. It's just that someone else might apply, another child might end up taking over it, and then they can apply and still get that exemption, because people have multiple children. They don't just have one. Another misconception is that, let's go down to the bottom one. A lot of, right. Yeah, a lot of people think, how many of you guys have more than one sibling? How many of you guys, right? I'm one of 3. So not all 3 of you have to live in your parents' home. God forbid you guys would drive each other nuts. So it only takes one person to live in the home to qualify for this exclusion. Whereas before, people were saying, oh no, everybody has to live there. That's not true. The problem with the family home is that it's not so much getting the exemption, as you can see, if one of you guys lives there. The problem is the equity that's built up in the home. And so that's why when people set up their trust, yes, someone gets the ability to live there, but the other people don't get to use the equitable value of the home, because maybe they want to pay for their own home, or maybe they want to pay for their kids' college tuition, or maybe they want to put towards a retirement, or maybe they want to X, Y, Z. It doesn't matter. If it's tied up in the home, unfortunately, you're not enjoying it. Only that one person is enjoying the benefit of it. So that's some of the things that have to be talked about when people come into my office is, yes, there's one home. Yes, you can keep on paying the same property taxes, but who's going to benefit from that? That's a very good topic. And you can go to the next slide. Let's give some examples of math. And I'm going to only keep it to this because you guys are going to fall asleep. I know it. All right, everybody get your pen out. I'm just joking, but if you want to, here's the example. This is like back to the SAT, right? How many of you guys did that? You know, they're doing away with the SAT.
Yeah, no, I know.
Nah.
Yeah.
All those years of being tortured doing the SAT, and then now they say the next generation doesn't have to take it. How is that fair? Are you guys upset about that? I'm upset about it. Why did I have to study for that? Anyways, all right. Where it says FBYYB, just, base year value. When you get your property tax and it says what the assessed is, that's your base year value. You bought the home for X and it increased a little bit, 2%. That's your base year value, just so you guys know. The example here is that somebody has a base year value of $348,000. I'm not going to say all the change. I'm just going to round it off. And so when you want to calculate what is excluded, you take the 348 plus the million. So now we're at 1.3, right, Brenda? So example one, the child lives in the home. Remember, you can't claim this exclusion while your parents are alive, because I get a lot of times people are like saying, oh, have I been living with my parents since 19 whatever? I'm all, congratulations. You never left the house. I call them the failure to launch. Anyways, I won't go into that's a hot topic. Anyways, they live at home, and then of course mom and dad die, and hopefully they have a trust and they don't have to go through probate, which makes things more streamlined, right, guys? You've learned that today. Trust means streamline. And the house is worth 1.1 million, right? So what you do is you take the 1.3, and then obviously the 1.1 is under the 1.3. And so there's no excess amount. There's no reassessment. Okay. Number two, example 1B, the child won't live in the home. I don't know, they don't like their parents' home in Downey. They think it's too antiquated and it's got a sunken living room back in the old days, and they have too much. What's it called? The shag rag, and then they have too many mirrors. Remember that? Some of those homes, and they have popcorn. It was in my parents' house. I'm basically describing you, and you're like, you guys are like, oh my god. Anyways, so the child won't live there. Okay. If he doesn't want to live there, then you're going to get reassessed. Cheddar coming, 1.1, 1% of 1.1. What's the math real quick? Good job. What's 1.5? Yeah, another 5. That's 15, 16, right? How many of you guys here got 15, 16 just to throw away? That's a lot of taxes, right? Anyways, example 2, the child lives in the family home, but now the home, instead of being valued at 1.1, it's actually 1.5, even more. Exactly. Well, here's where people freak out, where you shouldn't freak out. Even though it's worth more than the factored base value and the 1 million exemption, the difference is 151 in K. So really, you're only getting reassessed the 348 plus the 151. So you're only paying $500,000 on property taxes versus 1.5. I'll take that any day, right? Wouldn't you? Yeah, hell yeah. Otherwise, so it's not necessarily that scary, but the problem is it's not so much, there are people who qualify this, but the problem is when you have multiple children and you set up a trust, you got to really have this discussion as to who's really going to keep the family home and can they really afford to do it. And here's some other pearls of wisdom I'm going to give you. Some of my clients, what they do when they have multiple children, what they can do is the trustee of a trust can take money out of the house, get a line of credit, and they can borrow against the trust. And then if they have 3 kids and the house is worth 1.5, they can give 500,000 to one kid, 500,000 another kid. And then the other kid inherits a house with $1 million debt. And then they get their equity, right? And then they're living in the home. Siblings got cashed out. And then they're only paying on 500,000, right? Not bad. That's an equitable way of doing it. And so the trust allows you, what did I tell you at the beginning? Control. And to be able to do these type of plannings. But if you don't do this planning, you don't pre-plan, then it all goes to shit. And you're at the mercy of the court, or you're at the mercy of your kids fighting or not knowing what your intentions are, because at least this way you can set up some kind of a game plan and have, instead of having no game plan. So I wanted to go over these things right here. And obviously you guys can look at the other examples and stuff like that, but those are really great examples of how that works. And unfortunately, do you drink milkshakes?
Yes.
You like rubies?
Yeah.
I like rubies, right? Yeah. And what do? They give you a bigger straw, right? To suck up the milkshake. But now the state of California has given us a smaller straw to suck up our milkshake. And I hate that when you're trying to suck up the milkshake and you can't get it in. And you're like, what the hell? This sucks. And so that's basically what the state of California just did. They basically screwed with our milkshake. And now it's going to limit things, but it's not the end of the world. We can still do planning. And that's one of the things I wanted to share about you guys. Yes, it's a change in the law, but it can still be worked with. Make sense?
If you're the lucky child to get your parents home, how long do you have to stay there? Or do you get their new tax base? So if you decide to sell and go to another place in California, will you be able to take that tax base with you?
The answer is there. As soon as right here,
So Tony's question is, how long would the child have to live there?
You can be there as long as you want. You just have to make you have to be eligible within 1 year. See right here, 1 year, right? And if you move out, then obviously then the values recalculate, right? So you can be there as long as you want, but once you move out,
So at any point, like you can live there for 5 years, and then if you sell after 5 years, then you will have to pay.
you don't have to sell it, but maybe we talked about this earlier. Maybe one of your other siblings wants to move into mom and dad's house, and then they can still keep on paying it if they buy you out.
Well, what I'm saying is, you're the lucky one that you bought them, so you own that house.
Yeah, but
Now
it's,
you own that.
and as soon as you turn it into a rental, let's say, or you sell it, then you've lost obviously at that point, the basis.
Oh, so it's
So
you have to live there.
With you.
Oh, you're talking about the exchange over there.
Yeah.
Yeah, I see what he's saying. Tony wants it all.
Yeah.
I see how it is.
So he's thinking, live in the house, then make it a 1031 and 1031 it into a property in
Well,
Boise. I know where
yeah,
he's going.
I mean, yeah. Well, different states may not have obviously our Prop 19 and 13. Just so you know, we're unique in California that the Jarvis Act, that's the guy who passed or helped pass Prop 13. They may not be applicable in Idaho or Texas, but let's say, yeah, okay, Tony wants it all, like Tony Montana in that movie. All right, so let's assume you move into your parents' house, and then you have the tax bases, and now you don't like your parents' house because they live in a shitty neighborhood. And I'm not going to mention any neighborhoods so that I don't offend anybody out there in Zoomland or Hereland. So X neighborhood is not to your liking anymore, and you want to move to Y neighborhood, right? Well, you already made this your home, the declaration. So under Prop 19, it allows you to move anywhere else again. So yeah, you'll still keep that basis to X from X to Y, right? So you just use Prop 19 when you buy your new home, and then you carry over your parents' tax basis to the Y house. That's all.
And he's able to do that 3 times, the transfer?
Up to 3 times. You have to make the exemption. You have to make the declaration within a year. You don't have to stay there a year.
But Prop 19 only is California. He's thinking, what if he sells and goes to out of state? Now that doesn't, Prop 19 doesn't apply. Okay. Oh, you're staying here. Oh, okay.
You might not
I was saying
here.
Okay.
First of all, you have. And then you-
I mean-
now their home is much more expensive than yours, so you got a bigger.
Hey, Tony, anywhere outside of California, you're going to have Prop 13 anyways, because they're a lot cheaper than here
Yeah.
in a sense, right? If you move to Idaho, you're not obviously going to pay the same price that your parents' home is worth. So in a sense, you have Prop 13 because their prices are,
Yeah.
but it depends on how cheap, I guess, you buy.
Yeah, just the price of the home dictates that, right?
Yeah. It sucks. Not everybody has Prop 13, guys, but yeah,
Okay.
there's your answer.
Yeah. Any other questions?
Oh,
Or sorry.
well, I guess you have to look at your little screen.
I don't think, do we have questions? Any other questions?
I didn't want to take you guys too
Yeah.
long.
Okay, I
We've
think,
gone over.
we've gone over. Any closing?
Oh yeah, I mean, if you want to just go to the very last slide, the steps that you should take. I don't want to bother people going with all this stuff. I think my assistant gave you guys more.
Just a reminder, we will email this out to make sure everyone has it and the recording as well, if you want to listen to it, if there's anything that you missed. So we're going to get to the end and wrap it up.
Trust.
Oh, there it is. It was at the end.
It's towards the end. Sorry, bro. Keep going. I'm just gonna give you guys some steps to do. Keep going. Keep going. Keep going. Keep going. Almost keep going. Keep going. Keep going. And keep going. All right, here we go.
Okay, let's do all 6.
Yeah, yeah.
All right, here we go.
No one's forcing anybody to do anything here. This is all purely educational, just mind you guys. One of the things that we recommend is obviously number one is, so many people don't even know what their assets are or what they have. I can't tell you how many times people come into my office after a loved one passes away or is incapacitated and they're trying to figure out how much to pay for their monthly care or how much, they left behind. It's really important for yourselves and for your loved ones to create an inventory and update it periodically. If you have a life insurance that you're not paying life insurance premiums on them anymore and it's already lapsed, please don't keep it with your paperwork. Please don't keep your 1973 cash checks and bank accounts statements. throw those away. Also, write down what your objectives are. Some people want to have assets in the trust go a certain way to the one mijo, like Tony here. But other people might have a pension that will go to someone else and they kind of equalize it, you know, because they want to be fair. Also, if you want to do legacy planning for the grandchildren, you also plan in addition to your children. You may want to skip a generation and bypass the kids and give it to the grandkids because they're the ones that need it because the kids are already adults now and they're self-sufficient. Just examples. Select a professional. It doesn't have to be me. It could be anybody that's obviously licensed to do this. You don't want to, I mean, I'm not telling you to DIY it yourself and that's bad, not necessarily. It's just that if it becomes more sophisticated, you get what you put into it, obviously. And if you don't do it right, you don't want this blowing up in your family's face. You want to make sure that it's done professionally, done correct. I can't tell you how many times people have come to me where they started doing it themselves. Like that couple I told you, they have no kids. They're like, no, I don't, you know, we need help. Or they did the documents, but they never executed them properly. Or worse, they didn't put the assets that they need to put into the trust and properly fund it. It's a common mistake that I see. Prepare the documents, do them correctly. Also, don't just keep on saying you're going to do it. I can't tell you how many people say that, oh, mañana, mañana, and then they never get around to it. And then one of the questions here is, last question, we're interested in pour over techniques or other strategies to avoid rewriting our trust every time we have life changes. Well, so do I. I want to not have to change anything every time I have a life change. I'm just joking, guys out there. But if there's one thing that's consistent, what is it, guys? That there's always going to be change. So I had a client today that I told her, and she lost her husband recently. She's widowed. And I'm like, if you decide to remarry, that's cool. And she's like, oh, no, I'm not going to do that. I'm like, no, I'm just saying, I'm not trying to tell you, push you out there and do that. But I'm just, if it happens, please let me know because this will affect your documents, especially if you change your surname. Or if you guys get married, and then you might want to think about a premarital agreement so that you can protect your two daughters and make sure that that home that you have paid off in Beaumont. I told you she drove all the way from Beaumont, an hour and 40 minutes to go do her estate plan. Maybe you might want to set up a premarital prenup, as they call it, and make sure you protect your kids that way. Yes, that's going to involve, unfortunately, addressing the trust and then looking at your estate plan again, especially if you get married or if you get divorced. You might want to cancel the trust that you set up because you may not want your ex getting your half anymore. No offense, Brenda. Just kidding. And then obviously life changes. If you move to another state, I usually tell my clients your trust is still valid there because we have under the 14th Amendment, we have reciprocity. But I still people, if you're going to become a permanent resident of Utah, Idaho, Texas, or whatever, you might want to have a professional look it over there because they also have their state laws for their power of attorneys and their healthcare directives for their bodies. And you may want that to be updated. So when there's major changes in life, obviously, inevitably, I think that it's something that you're going to have to revisit and take a look at and then inevitably make the necessary changes. So there's no way of avoiding it. I'm sorry. So that's the answer to that question. And then, of course, review it and make changes as needed. And that goes to that answer right there. No one's forcing you to do this, but the problem is that this document is only as good as some people can understand it. And when people make a whole bunch of changes, it looks like a pancake stack, and then you can't really understand. Read section 2.A.C. and then look at this section. We do what's called the amendment summary statements, where we remodel the trust. You know, when you guys have a house and you start off, and then it's like it looks great back then, but then it starts falling apart, and then obviously it needs a refresher. And I think of the amendment and restatement like a refresher of your trust, so that if it's a bunch of confusing language before that doesn't make sense, then this new version of the trust replaces the other trust and it becomes the one that you want to have honored. And I constantly tell my clients, you need to look at these things. You need to refresh them as needed. Your life is going to change, and it's on you guys, basically, at the end of the day, if you want to leave clarity to your family or not. End of story. So those are my plans of action. More importantly than anything, educate yourself like you guys are here today. Educate yourself in Zoom land. The education is the best thing you can do. And obviously, put the plan in action.
Yeah.
basically.
Make it happen. Thank you so much, Allan, for being here. You all know that we're very committed to education, and we really ultimately, we know how hard everyone works for their wealth, and we really want you to protect your wealth. And Allan, you're here because I personally trust you. I've referred a lot of clients, family, and you are the best. So I'm going to give you that plug.
Oh, thank you.
So thank you for being here and taking time out of your busy schedule to be here. I wanted to remind everyone that next Wednesday, we have a homebuyer seminar set up as well. So we will email that out to everyone. If you or anyone you know is thinking about purchasing a home, whether it's in the next month or in the next year or two, please have them join. There's a lot that's been changing. So thank you again on behalf of myself, Vivon, Tammy, and Natalie, and the whole VB Realty group. Thank you so much for being here, and we'll see you next time. Good night.
All right.